We've got a lot of Second Amendment litigation heading to the Supreme Court. We've been talking about it for a couple weeks now. We're going to continue to talk about it going into 2026, but the Ninth Circuit is still working, and we saw oral arguments just a couple of weeks ago in the Sanchez v. Bonta case, which is our challenge to the suppressor ban here in the state of California. Let's talk about it. Hey everybody, welcome back to the channel today. You know, in all this talk about the Supreme Court and Duncan and some of these other 2A cases that we've got going on, while we're also looking towards the end of the year, I didn't necessarily want this one to get laid by the wayside. So we did have oral arguments in the Sanchez v. Bonta case just a couple of weeks ago. I thought we could go through it. This is a big one. This is a big request that we have continued to get over the last couple of years, just to get participation in the suppressor argument, which Sanchez v. Bonta is. So to walk us through that, we have brought back Anna Barvir. She is a partner at Michel Associates. She's going to walk us through that one today. Anna, thank you very much for being with us today.
As always, thank you for having me.
Absolutely. And once again, guys, please be sure to like, share, and subscribe to these videos. Really helps get the information out there as far and wide as possible. We're trying to get the clearest picture we possibly can going into 2026. There's a lot of litigation, a lot of potential happening at the Supreme Court and the Ninth Circuit through the beginning of next year. So we're trying to create a clear picture for that. So go ahead, like, share, subscribe, throw some comments down in the comment section below. Really appreciate it. That really helps out the channel. So Anna, let's go ahead and dive on into this one. A little bit of an awkward entry into the suppressor case for CRPA. Can you go ahead and remind us, what is the challenge here in Sanchez v. Bonta, and how is it that CRPA came to be participating in this case at the Ninth Circuit?
Very good question. So our client, Gary Sanchez, initially brought this lawsuit against California's restrictions on suppressors as a pro per, meaning he filed it, he created the case and filed it, brought it on his own behalf. And he was litigating the case on his own behalf in the lower court. And it was ultimately, dismissed. He was challenging it because I believe he was he had wanted to be able to 3D print and create his own suppressors when he applied for the permit that he needed from the federal government. It was denied because of the suppressor ban that was in effect, or is in effect in California. So he, on his own behalf, brought the lawsuit. Again, it was dismissed in the district court, and then he appealed his loss to the Ninth Circuit. After briefing had been completed by both Mr. Sanchez and the state, the Ninth Circuit decided that it wanted to hear a little more, and so it issued an order, indicating that the court was interested in assigning counsel to Mr. Sanchez so that he would have a licensed and practicing attorney arguing this case on his behalf. And I think that that's important, and it's sort of unusual for the court to kind of take that away from him, especially in a civil case. But it does indicate, at least in my opinion, that the court is really interested in hearing the strongest legal arguments it can, usually brought on behalf of by lawyers, and then it wants to decide this, and it understands how important and widespread the decision could have, the effects it could have. So the court issued that order, and CRPA, through Michel Associates, our firm, reached out to Mr. Sanchez, as did attorneys at Cooper Kirk, and worked with Mr. Sanchez to indicate that we were not interested in having the Ninth Circuit judges assign counsel, but instead Michel Associates and attorneys at Cooper and Kirk would step in and take up Mr. Sanchez's case. And after that, the court agreed and said, okay, attorneys from Michel Associates, attorneys from Cooper Kirk, we accept you're now representing Mr. Sanchez, but we'd like to have new briefing. So the court issued deadlines to file replacement briefs, which our office worked with the great attorneys at Cooper and Kirk to create to draft new briefing, and it was filed this spring. And that led us to oral arguments this fall.
Right. And the oral arguments they did hear, like I said, just a couple of weeks ago. There were a couple of interesting moments. And I think even with you, Anna, we've gone through several oral arguments, been trying to watch as many as I possibly can over the last few years just to see not necessarily where the cases are going, because we've discussed this plenty before, but the questions that the judges have specifically. Because, guys, remember, I mean, these judges read these briefs and we come to oral arguments to kind of just formulate any other questions that the judges may have and put those questions to rest. So you may have an entire 40-minute oral argument and not even necessarily discuss the bigger question, which of course here is, should California be able to ban the possession and purchase of suppressors? But there were a couple of really interesting things. So Jacob, if you could, let's go ahead and roll the first clip and let's see.
Yeah, of course, the core of the Second Amendment seems to be self-defense. So if one is forced to defend oneself, one may or may not have time to attach a suppressor if it's not already there. One may have chosen not to put the suppressor on because it makes the gun more cumbersome, more difficult to get out of wherever it's been holstered or sequestered. So I'm not sure how B&L, that's a very, very high level of abstraction. Because it doesn't meaningfully constrain the core right of the Second Amendment to self-defense. Well, it doesn't impair the shooting of the gun.
Well, Your Honor, I'll respond in a few ways, Your Honor. First, the Second Amendment protects all lawful uses. That's what Heller says, that's what Bruen says, whether things are in common use for lawful purposes. Heller specifically mentions hunting, it talks about training, so those are clearly covered. But even if we're gonna look just at self-defense, training itself facilitates self-defense. California requires people to train to get carry licenses. It's obviously something that is beneficial. And again, the CDC, this was in a NIOSH report about students and trainers at training facilities, said that the only potentially effective noise control method for reducing students and trainers' exposure to noise from firearms is suppressors. So the banning of suppressors meaningfully constrains training, and training, I think everyone would agree, is a protected activity that itself facilitates self-defense.
Okay, so Anna, this clip pertains specifically to training, which I thought was kind of interesting. It's not exactly an argument that you hear a whole lot of, but the logic kind of follows, right? If they are going to require us to do training in order to have something like a CCW, and even in the last couple of years, we've seen bills, of course, we killed them, but we have seen bills that have been proposed that would require training just to purchase a firearm in the first place. If they're going to require that kind of training in order to possess a firearm or have a CCW, would it follow that training should fall in the boundaries of the Second Amendment?
So I'm hearing a few strings of questions in your question there, and the first I think I want to address is whether or not this is an argument that we see regularly or that we have previously, that we've previously put forth. And I think that what happens a lot of times, because Heller and all of its progeny have spoken so heavily and focused so much on self-defense, a lot of times arguments and especially and the decisions that are coming from lower courts and circuit courts focus on this right to self-defense, and they're talking and they tend to get wrapped around that axle and forget that Heller doesn't only speak to self-defense, it speaks of lawful purposes including self-defense, and of course things like hunting and recreational sports with regard to firearms, and of course, as you're mentioning, training. These are other lawful purposes, and they're equally lawful purposes. And so it seems to happen that a lot of times the attorneys and the courts start to get wrapped up in self-defense, and sometimes the arguments about training and other sports purposes fall by the wayside, or they don't get as much airtime. But the fact is, we have been bringing these arguments for years. We've been bringing them since Heller, and I think one of the earliest examples your viewership might be familiar with, of course, is Zell, where the government required training at a range, and then removed all the, then also banned ranges from within the city. And so people had to leave the jurisdiction in order to do the training. The court recognized there that, well, if you're going to require training, you can't also ban the training and where the places that the training is going to happen. And so it's not super new, but it is also, like I mentioned, an argument that oftentimes falls by the wayside. And in this case, it's super important, and to answer, I think, to more specifically answer your question about whether or not it does follow that if a firearm or a firearm part, or in the terms that they used in Duncan, an accessory, is something that's necessary for or important to be used in training, whether or not, and that training is to prepare yourself for self-defense, whether or not it would follow that it should also be protected by the Second Amendment. And of course, I think that's true. And it's, I think it even has, you have a much even stronger argument when you're talking like you were about the government then also requiring you to have training so that you can have a CCW, or in some places get, have a firearm at all, to purchase a firearm at all. So when you're putting the training requirement on, as a prerequisite to exercising your rights, especially your right to use firearms in self-defense, certainly it follows that they would be protected. But in my opinion, it's just the wrong question, right? Because firearm, it's not whether or not those inanimate objects are themselves protected or not. It's whether or not you use those objects in furtherance of your exercise of the right to keep and bear arms, and specifically for purposes like training or self-defense or recreational purposes.
Yeah, it definitely does. And that kind of makes sense. I mean, it's not necessarily about an inanimate object being legal or not. It's about being able to exercise the right, which definitely makes sense. And I think, based off my own perception here, watching these oral arguments, it seems like the attorney arguing for plaintiffs had a little bit of a better day than the state's attorney. But we do have a clip for you guys, kind of an interesting thing here. Jacob, go ahead and roll this one.
Is there any indication that suppressors are actually used for criminal purposes, or it enhances criminal purposes?
I think there are. It is rare, to be sure. There are instances where suppressors have been used in criminal situations. But again, I don't think that's the relevant analysis, because I think the same thing could have been said about large capacity magazines, which were widely owned and yet rarely used for mass shooting criminal purposes.
So if they're not arms, the analytical framework would just be, just rational basis?
Yeah, I think that's right. Yeah, if they're not arms, or if they fit into this court's corollary right under FIOC and Jackson.
Could California ban recoil pads, pads they use for shooting rifles, so there's less recoil, you don't get injured, and you have more accurate shooting?
I think the analysis would turn, well, that obviously wouldn't be a weapon. It would be beneficial. And I think the analysis would turn in that case whether there was evidence that it was integral to the operation of a gun. And as I'm sitting here working through that, I don't think it would be. So things like arm braces, and federal courts have found that shoulder braces, things of that manner that aid in the use of a firearm, are not subject to the Second Amendment's constitutional protection.
Pretty sweeping power for the state to ban things and that are used for lawful purposes and probably pose no danger. But now under your reading of Duncan, it seems like California can ban anything that actually is helpful to gun owners, makes it more safe to use.
Okay, first of all, pretty sure he just admitted that large capacity magazines are widely owned and rarely used in mass shootings. Wonder if a clip like that ends up getting put into a briefing for Duncan at some point. But having said that, the other part that he was talking about here is kind of what I wanted to focus in on, Anna. And I guess the broader question is he saying the quiet part out loud? Like, if what he's saying is correct, and suppressors are not arms, that, by itself is rational to think that the government can ban anything that doesn't qualify as arms. Is this kind of the overall plot that you see happening with a state like California, where they just want to make sure and identify every single piece as not an arm so they can continue to ban them?
And this kind of, I think, builds on what I was trying to say at the end of my last response. To specifically and expressly answer your question, yes, what the state needs to do in order to overcome the Bruen analysis that puts it squarely on the state's shoulders to justify its laws based on history and tradition. If they have to get there, they're going to lose so many times, right? And they know that. So they need to get the court to follow along an analysis that says that they don't even have to get to the part where they're justifying based on history and tradition. They need to say, well, this is something, the conduct that we're regulating isn't even within the scope of the Second Amendment. And that's what, I mean, obviously what they have to do, right? They want to, because they know that if it's within the scope, they've got to justify on history, and there's so little there, right? That is going to allow them to, in a lot of cases, especially arms possession ban cases, there's gonna be anything that they can find in history to justify the modern laws, the modern bans that they have. So yes, that's what they're doing. But again, I think that's just absolutely the wrong question. When what we're seeing the courts doing, the lower courts doing, and it's happening and growing in the Ninth Circuit ever since BNL, where the court starts to ask questions specifically, is there a meaningful constraint on the right to bear arms? And if we can say that a suppressor is not an arm, or if a magazine over 10 rounds is not an arm, well, certainly then it's not a meaningful constraint on that Second Amendment right to bear arms. And that isn't the question, and that's not the analysis after Bruen, but it's what they're doing. And whenever you see the Ninth Circuit starting to do an analysis, it says, well, this isn't really the right to keep, it's not really the right to bear, and it's not really an arm, then you know that they're going to start going down this revived two-step, pre-Bruen analysis of, is this a significant enough of a burden on your right to keep and bear firearms? And is it within that core right for self-defense? So it starts bringing up questions of whether or not training is enough, whether or not a magazine is an arm, whether or not a suppressor is an arm. And again, I just think it's the wrong analysis, but it's what the state's got to do in order to make its win, because the history is not going to support them on bans of arms and items that are used in furtherance of your right to keep and bear arms.
Well, that's fair, and that is the playbook identified, which I guess also kind of continues to clarify and identify the public outcry that we have for the Supreme Court to continue and nail down the scope by which these courts are supposed to view Second Amendment litigation. To clarify that question would make this kind of an automatic answer, and we know what that answer would be. But until then, we need to continue and have these arguments. I'm sort of curious what your thoughts are on this, and this is something I've just kind of been thinking about a little bit. Guys, if you watch these oral arguments, you'll see this all the time. Generally speaking, there are judges that are more talkative than others. And in my experience, Anna, I mean, what you generally tend to see are that judges will ask more questions and harsher questions for the side that they aren't going to agree with. But my question to you is, because there's always a judge that, or not always a judge, there sometimes is a judge that says nothing. And that's kind of what we saw from Judge DeAlba here in these oral arguments. What exactly do you make of, if there's anything to make of, a judge on a panel? I know that you've done plenty of Ninth Circuit oral arguments yourself. What do you make of a judge sitting on that panel that literally says nothing the entire time?
There isn't really much you can take from a judge that doesn't say anything or much. They run the gamut as to why that is. You might recall from our slam dunk win in our second appeal in junior sports magazines, Judge Van Dyke was on that panel, and he didn't say a word, even though we knew how he felt. We know how he felt about that second appeal, how he felt about the first appeal. You have, I think it was Justice Clarence Thomas, who was, I mean, well known. He was famous for not speaking during many, many oral arguments for years. And so whether or not they ask a lot of questions, it may be because they have their mind fully made up. They don't have any questions for you. It may just be their bench personality. They may not ask questions almost in any case. That would have to be something you'd have to review lots of panel seatings of that judge to see. And so when it comes to trying to figure out what a judge that doesn't say anything, where they're leaning. The best we usually can do is sometimes which president nominated them. Hopefully that's not a huge tell. And they're ruling based on the law instead of political views, but we know that that's not always true and realistic. But also any history of Second Amendment cases and decisions that they've made in previous 2A cases, if there are any, that's a way we can look. But the fact that they say or don't say anything during our oral argument it doesn't really tell us anything. And even judges that do speak a lot, the ones that ask a lot of questions, they may be doing, devil's advocate. They may be trying to tell that judge, to signal to that judge that's not saying anything on the panel, like, here are some questions that I know that have been swirling around in your brain, and I'm going to ask them, and I'm going to get the attorneys to verbalize response so that you can get thinking on those issues. Or I know that you have your mind made up in this way, but here's something that maybe you haven't thought about, and I want to hear what the parties have to say. And so they may ask questions and seem to be asking hard questions of the party that they agree with or disagree with. But it may be, maybe asking hard questions of the attorney's party, the party for the attorneys or the parties that they agree with. But what they're doing is they're trying to get to pull more out of the party's counsel so that they can help their colleagues answer questions that they've been debating in the background. So you can't always tell by the way the questioning is. Sometimes you can. It's obvious. You're going to have your super friendly judges. You're going to have your super hostile judges, and then you have your silent ones and your the devil's advocate type. So it's the best we can do to decide what decision we're going to get is how oral argument goes, but it's not always.
Well, that's fair. And I guess the silence of a judge just makes it a little bit less of a spectator sport for us. I know that I definitely fall into that category of wanting to figure out where all three judges stand on this so that we can get an idea of the decision that's going to be made going forward. But so, without anything substantive, which is kind of what you're making it sound, maybe just a little bit of a spectator sport for us. Having said all that, Anna, what do you see going into 2026 with this? And correct me if I'm wrong, but you got to feel good about a court that says, hey, why don't you bring in some experts here to help you out with this? Let's go ahead and hear it. Based off of the questions that we were hearing from a couple of the judges on the Ninth Circuit, it seems like this case could have a positive path ahead of it. What do you make of these oral arguments? And I know that there's no timeline on opinions, but how do you see this going into 2026?
Well, I mean, you're right. I'm always the one to tell you that we never know when they're going to decide. In junior sports, that second case was easy, and we had a decision within 2 weeks. This isn't, I think, going to be one of those cases. We probably won't see anything for the first of the year. We have a pretty good feeling, I think, for two of the judges, but we have to hope that we were able to convince Judge Bybee that our position is the correct one. He doesn't have the strongest track record on Second Amendment cases, but I do think there was enough. There was enough for him to grasp onto in arguments, both written and during oral argument, that we may have been successful in getting a positive 2-1 decision. And I'm hopeful to see that. But again, we won't be able to know until the decision is released.
Well, I would much rather take potential positivity into the new year than potential negative. So we're going to stick with that. Obviously, as always, we're just going to have to wait for the opinion, and we will do so and definitely be revisiting when we see that. Anna, I know that you are busy. I know that the end of the year holds a lot of promise, but I do want to thank you for taking the time and coming on with us today. Thanks for being here.
Of course, I'm always happy to be here.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to these videos. It's a great way for you to directly contribute to the Second Amendment movement here in the state of California. So please go ahead, like, share, subscribe, throw some comments down in the comment section. We do have our year-ending videos coming up. We're going to be recapping litigation, legislation, Trump DOJ, things like this, some amicus briefs, really round out the year 2025 to see what that picture looks like going into 2026. So make sure those notifications are on as these videos come out so that you can watch them right when they do come out. Thanks again, guys. We'll see you on the next one.